Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 17th lecture, and today's topic of discussion is role of NHRC and SHRC in protection of human rights. So, in this lecture, I would like to discuss role of National Human Rights Commission and role of State Human Rights Commission in protection of human rights. How these human rights commissions, particularly National Human Rights Commission and State Human Rights Commission, both have been effective in protection of human rights in this country. As you all might be knowing that Indian Parliament in 1993 enacted a special legislation for protection of human rights. The name of that special legislation is the Protection of Human Rights Act 1993. So, under that statute, it is specifically mentioned that central government by its notification may establish National Human Rights Commission at central level and State Human Rights Commission for each and every state. For what? For the protection of human rights. So, it is very pertinent to mention the meaning of human right provided in section 2D of the Act. Section 2D of this Human Rights Act 1993 defines human right. According to section 2D of Human Rights Act 1993, human rights are those rights which are enshrined in any international instrument or recognized in the part 3rd of the Indian Constitution and which are enforceable by court of law. This is the definition of human right provided in section 2D of the Human Rights Act 1993. So, you can understand the meaning of human right in the light of this statutory definition section 2D. You all might be aware about two school about human right. There are two important ideology. One is analytical school of jurisprudence and another is natural school of jurisprudence. According to a scholar of analytical school of jurisprudence like Austin and Salmond, Holland, Bentham, they argue that all the rights are creation of the state. All the rights are recognized and protected by the state. On the other hand, the scholar of natural school of jurisprudence, they argue that human rights are above the law, state cannot make the law. So, they do not believe state enacted law, state created law. On the other hand, analytical school of jurisprudence believes in state recognized law. So, in the light of these two contradictory views, in the light of these two contradictory ideology, we will try to understand the meaning of human rights, the meaning of human rights provided in section 2D. But section 2D of this act is very close to analytical school of jurisprudence, because section 2D says that human rights are those rights which are recognized in any international instrument or in the part 3rd of the Indian Constitution and enforceable by court of law. Means all the rights which are not enforceable by the court of law cannot be treated as human right. Meaning thereby we can say that the rights which are enforceable by the court can only be considered as human right. And section 2D also recognizes international instrument like international Covenant on Civil and Political Rights 1966, Universal Declaration of Human Rights 1948. So, you all need to understand those human rights provided in UDHR and International Covenant on Civil and Political Rights. For example, right to life, right to equality, right to food, right to marry, right to education, right to livelihood, right against illegal arrest, right to free legal aid, right to legal aid. These are right to fair trial. So, well, students, I was talking about human rights, and a scholar of these two important ideology, they have tried to understood human rights in their own perspective, in their own understanding. So, section 2D is very close to analytical school of jurisprudence. As per the content of section 2D, we can understand that definition of human right provided in section 2D is very close to the view of analytical school of jurisprudence, to the ideology of analytical school of jurisprudence. And I have also highlighted some important human rights provided in UDHR 1948, like right to education, right to equality, right to life, right to food, right to medical aid, right to marry, right to legal aid, right to free legal aid. These are human rights provided in UDHR 1948, right to fair trial, right against inhuman treatment, right against presumption of innocence. So, protection against illegal treatment, inhuman treatment, illegal arrest. So, these are human rights provided in Article 5, Article 10, Article 11 of UDHR. So, now with the help of this slide, I would like to you just look at this slide. Right to equality, Article 1 talks about Article 1 of UDHR, Article 3 right to life, UDHR, right against torture and inhuman treatment, Article 5 UDHR, Universal Declaration of Human Rights 1948, right to fair trial, Article 10, presumption against innocence. The entire emphasis of criminal jurisprudence is this Article 11, presumption against innocence. And on the other hand, human rights provided in UDHR have got recognition in the part 3rd of the Indian Constitution. I have referred these rights, fundamental rights, in part 3rd as right to equality, Article 14, right to life, Article 20. You can compare human right with the fundamental right provided in our Constitution in the part 3rd of the Indian Constitution. Right to be produced within 24 hours to the magistrate, before the magistrate, right to be represented by counsel. These are human rights as well as fundamental rights. Human rights provided in UDHR, Universal Declaration of Human Rights, fundamental rights, we have recognized these rights, human rights, as a fundamental right in the part 3rd of the Indian Constitution. So, in the light of these two document, constitutional law and UDHR 1948, we will try to understand how NHRC and State Human Rights Commission and National Human Rights Commission have been effective in protection of human rights of the citizen of this country. So, how National Human Rights Commission has played important, to what extent National Human Rights Commission has played important role, to what extent State Human Rights Commission has played important role in protection of human rights of the poor people, human rights of the person, particularly how far Human Rights Commission, National Human Rights Commission has been effective in protection of human rights of arrested person, human rights of the prisoner, human rights of the farmers, human rights of the poor people, female offenders. So, we will try to understand these human rights in the light of judicial pronouncement. Though National Human Rights Commission is obliged to protect human rights of the citizen of this country. Irrespective of caste, creed and religion, National Human Rights Commission has to come forward wherever the cases pertaining to violation of human rights are reported. It is statutory obligation of National Human Rights Commission as well as State Human Rights Commission to come forward to protect the rights of the individual, the rights of the people against whom atrocities are committed, against whom state or individual has violated the human rights of the individual. So, Human Rights Commission is obliged to take action against the wrongdoer. I will try to explain the role of National Human Rights Commission and State Human Rights Commission as well as advantages and disadvantages, merits and demerits of National Human Rights Commission and State Human Rights Commission. What are the merits of these commissions and what are the demerits of these two commissions, whether these two commissions have been failed to protect human rights or have been effective in protecting of human rights, we will try to understand with the help of statistics data available on the website of Human Rights Commission. You can just get information regarding violation of human right, regarding police atrocities, custodial death, custodial violence from the website of National Human Rights Commission. All the informations are available on the website of Human Rights Commission. With the help of that statistics, we will try to understand whether National Human Rights Commission or State Human Rights Commission has been effective in protection of human rights or not. So, let us understand this Protection of Human Rights Act 1993 and the role of NHRC. Just I want to refer role of NHRC in this slide. You see, it inquires, this is incorrect. It inquires into violation of human rights. What is role of National Human Rights Commission? I have just referred this in this slide. I have highlighted the role of NHRC in this slide. It inquires into violation of human rights or abatement of such violation or negligence in prevention of such, where authority has failed, where authority is negligent in prevention of such violation by a public servant, either suo motu NHRC can take action or on a petition by victim or any person on his behalf or a direction or order of any court, where court has issued direction to the NHRC, then NHRC will come forward. In brief, I am referring NHRC. Instead of referring National Human Rights Commission, I would like to refer it NHRC. NHRC plays an active role in taking cognizance cases of human rights violation by awarding compensation to victim of crime and recommending authority concerned to take action against the wrongdoer. NHRC has to examine the conditions of prison inmates where prisoners are detained or lodged in prison, reformative homes, and NHRC can make a recommendation that by what means, by what methods the position or the condition of prison may be made better or good. So, with the help of this slide, you can understand it has to review constitutional and statutory safeguards related to protection of human rights. It also spread human rights literacy among various sections of society. NHRC has to. So, what now let us understand the role of NHRC, which I have highlighted in this slide. The most important contribution of NHRC is NHRC has to come forward wherever the cases regarding violation of human right is reported, is brought into the notice of this commission NHRC or SHRC. The entire team or member of NHRC or SHRC, they will appear, they will go to the place of occurrence, they will collect information, they will collect all the relevant information from the victim of crime against whom atrocity or against whom wrong is committed. So, member of this NHRC or SHRC, they go to the place, they have to visit the place of occurrence, they have to record the statement of victim of crime, they have to take action against the state official. Many times you might have seen that in case of custodial death, in case of custodial violence, the first voice which is raised by statutory agency, that is the voice of National Human Rights Commission, or it may be the voice of State Human Rights Commission. Recently you might have seen that one incident took place in West Bengal, and entire media have attracted the mind of viewers that a particular place in West Bengal has nowadays has become a place where human rights of the poor female have been violated by the wrongdoer. You see person who has violated the human rights of those poor female might be arrested, and Human Rights Commission, what I am trying to justify, you see Human Rights Commission has taken initiative in that, and Human Rights Commission has asked the government, state government concerned, to provide details about that incident. And so in this way I will try to explain you that how Best Bakery case in Jahira Sheikh was state of Gujarat, National Human Rights Commission intervened in the matter, how National Human Rights Commission intervened in fake encounter committed in Andhra Pradesh, and how National Human Rights Commission reported a case when an incident took place in Lakhimpur during farmer agitation few years back. So, we will try to understand the efforts made, initiative taken by National Human Rights Commission in order to protect human rights of the farmers, human rights of the poor people. So, this you see another important task which has been assigned to National Human Rights Commission under this statute, the Protection of Human Rights Act 1993, this Human Rights Commission has to spread awareness among the people about human rights. What are their human rights? What are the human rights of the people of this country? So, it is the legal duty of this commission, National Human Rights Commission, to make people aware about their human rights, particularly poor people who do not have idea, who are not aware about their human rights. So, it is legal duty of National Human Rights Commission to make people aware about their human rights. And it has also to review the conditions of jail authorities. National Human Rights Commission as well as State Human Rights Commission both have to monitor the things which are going on inside the prison. So, apart from this, the demerits of this Human Rights Commission is, it is many times it is argued that National Human Rights Commission is only recommendatory body. Suppose if police has committed atrocity, if custodial violence is reported, custodial death is reported, National Human Rights Commission accept making recommendation to the superior police officers that action should be taken against the police officers who were involved in the incident, except making recommendation. NHRC cannot take action against the wrongdoer, against the police officers who have committed custodial violence or custodial death. So, this is the demerit of National Human Rights Commission. Many times it is argued that National Human Rights Commission and State Human Rights Commission, these two agencies are recommendatory body. They can only recommend, they cannot take any action against the wrongdoer. So, what is the use of these two committees? If these two committees are making recommendation only, on the basis of recommendation, action would be taken or not, it depends upon the superior authority. It depends upon the superior police authority, police officers, whether they are going to prosecute, whether they are going to take any departmental action against the police officers or not, it is up to the police officer. So, National Human Rights Commission or State Human Rights Commission cannot take any tough action against the wrongdoer, against the police officer. Or so, this is the demerit of this commission, and this commission many times is said that these two commissions do not take any effective action against the wrongdoer. Now, let us understand the cognizance of important cases which I have highlighted in this slide. You just look at this. NHRC had taken suo motu cognizance of media report. NHRC approached the Supreme Court on behalf of victim of Gujarat riots. This case is known as Best Bakery case. Case of the name is Zahira Sheikh versus State of Gujarat. AIR 2004 Supreme Court. This case is popularly known as Best Bakery case. Best Bakery case. Starvation death was reported in Odisha. So, NHRC took suo motu cognizance, and in this PUCL versus Union of India, AIR 2001 Supreme Court held that right to food is a fundamental right under Article 21 of the Indian Constitution. NHRC also took initiative in fake encounter which happened in state of Andhra Pradesh. So, I will try to discuss these three different incidents one by one, so that you can get entire information about effective role played by NHRC in protection of human right. So, let us understand the facts of Zahira Sheikh case, where National Human Rights Commission has played important role. What happened in Zahira Sheikh case? You see, after Godhra incident, a ruling mob entered into the premises of Zahira Sheikh shop, and when ruling mob was trying to open the door of the Best Bakery shop was being run by father of Zahira Sheikh. So, father of Zahira Sheikh along with few laborers, workers who were working in Best Bakery shop, they shut the door and they tried to take shelter inside the shop. But that ruling mob looted the shop and killed workers along with father of Zahira Sheikh, who was also killed in that incident. So, matter was, since Zahira Sheikh was eyewitness in that case and she lodged FIR in that case. But you see, meanwhile, since this was a very sensational incident, so National Human Rights Commission also intervened in this case, and when trial was conducted, all the accused were acquitted by the trial court in the absence of evidence. The matter was brought into the notice of Supreme Court that all the accused in Best Bakery case were acquitted by the trial court. So, then Supreme Court decided to transfer that case from Gujarat to Bombay, and when trial was conducted in Bombay, the point which I want to highlight is, you see how National Human Rights Commission intervened in this case, and because of the intervention of National Human Rights Commission, the matter was transferred from one state to another state. So, to some extent we can say that National Human Rights Commission has also played important role in providing justice to the victim of crime. Another important case which you all might be knowing, that where starvation death was reported in Odisha, and people who were not in position to manage their food, and particularly tribals, scheduled tribes people who were living in Kalahandi and Kochar, Mayurbhanj district of Odisha. Media report revealed that many people died due to starvation death. And you see, report was published in a newspaper. Matter was brought into the notice of National Human Rights Commission. National Human Rights Commission took cognizance suo motu. Meanwhile, PUCL, People Union for Civil Liberty, filed a petition in Supreme Court by stating entire facts that country like India, where this country is independent in food grains, and Food Corporation of India FCI has sufficient adequate food grains. In spite of that, we are not able to prevent starvation death. So, PUCL filed a petition in Supreme Court by highlighting that incident, and Supreme Court took the cognizance that Supreme Court held that in this case PUCL versus Union of India, Supreme Court for the first time held that right to food is a fundamental right under Article 21 of the Indian Constitution. This right to life would be meaningless for those poor people who do not have sufficient means, who are unable to manage their food. So, it is legal obligation, it is constitutional obligation of state to protect life and limb of a citizen. It is constitutional obligation of state to provide food to those poor people who are unable to manage their food. So, right to food was considered as essential component of right to life guaranteed under Article 21 of the Indian Constitution. For your kind information, all the students must remember this case, because this is the case, and this case has laid down foundation of social justice in this country, because in this case Supreme Court for the first time recognized right to food as a fundamental right, as essential component of right to life guaranteed under Article 21, without providing food to those poor people who have died due to starvation death, due to hunger in this country like India. That right to life would be meaningless for those poor people, where state has failed to provide food to its poor people. So, Supreme Court in this case for the first time held that right to food shall be considered as essential component of right to life. It is directly connected, food is directly connected to save the life of people, and we cannot hope right to life would be sustainable. Right to life provided in 21 would be materialized unless we provide this food to the poor people. So, this is another important case where Supreme Court has played important role, and National Human Rights Commission has also played important role in exposing, in attracting the attention of starvation death, and Supreme Court was also attracted attention, this National Human Rights Commission attracted the attention of Supreme Court, and in this way this right has been recognized as important right, fundamental right. Another important incident where National Human Rights Commission intervened, you might have seen that in Andhra few months back in Andhra Pradesh, where police killed some criminals in an encounter where those criminals were involved in gang rape. So, though the act which was committed by police in order to maintain law and order, fake encounter. So, National Human Rights Commission came forward and said that this is a case of police atrocities, police officers should not take law in their own hands. even police officers, they cannot take law in their own hands. So, this is a fake encounter, but ultimately the point is that National Human Rights Commission also, many times you might have seen that National Human Rights Commission brings the case into the notice of the court or brings the case into the notice of superior police officer, so that the same incident could not be repeated. So, with the help of these three incidents, another important incident which took place in Uttar Pradesh, Lakhimpur district, where National Human Rights Commission also intervened. So, it is duty of National Human Rights Commission and State Human Rights Commission. Now, come to this another aspect of National Human Rights Commission. With the help of this slide, I will try to explain you the role of NHRC. You see, right to live with human dignity, you all might be knowing, you all might be aware about right to live with human dignity, right to life, protection against self-incrimination, Article 20 Clause 3, fundamental right, you all are aware. Third important case which I would like to discuss, that is Selvi, Srimati Selvi and others versus State of Karnataka, AIR 2010, Supreme Court. And third is protection against torture, Article 5, Sunil Batra case. So, the important case which I am going to discuss, that is Selvi and others versus State of Karnataka, AIR 2003. So, the role of NHRC in scientific investigation has become very important nowadays. You see, Article 20 Clause 3 protects an accused not to confess his guilt, not to become a witness against himself. It would be a violation of fundamental right guaranteed under Article 20 Clause 3. In Selvi, you see what happened in Selvi case, Selvi and others versus State of Karnataka. The daughter of Selvi, she wanted to marry with a man of other caste, but Selvi, Srimati Selvi, she was not happy with the proposal of her daughter. Srimati Selvi, she requested to her daughter that her daughter should not contract marriage with a man who belongs to different caste, but in spite of that they got married. But after few days that man was brutally killed, and the doubt, suspicion raised against Srimati Selvi and two other persons who were involved in that incident. So, they were arrested, produced before the court, and now investigating agency filed a petition before High Court that so you see before Session Court, that Session Court should give order for narco analysis or brain mapping test. Trial court issued permission, gave permission to the investigating agency that narco analysis test can be conducted. Being aggrieved, Srimati Selvi filed a petition in Karnataka High Court challenging the order of trial court that accused should not be compelled to give confession, to give a statement against her will, because it would be violation of Article 20 Clause 3 of the Indian Constitution. So, that a petition was filed on behalf of Srimati Selvi in Karnataka High Court, and Karnataka High Court also upheld the decision of trial court. So, being aggrieved, Srimati Selvi filed SLP, especially petition in under Article 136 before the Supreme Court, seeking permission from the Supreme Court that it would be violation of fundamental right guaranteed under Article 23 if they are allowed to undergo for narco analysis test or brain mapping test. So, you see in this case National Human Rights Commission has already issued various guidelines For investigating agencies who are willing to conduct narco-analysis test or brain mapping test, investigating agencies have to follow those procedures, parameters prescribed by National Human Rights Commission for conducting scientific techniques, methods like narco-analysis or brain mapping. So, this case is important. What I am trying to justify? I am trying to justify that National Human Rights Commission has played important role in highlighting in protection of human rights of the citizen of this country. So, how you see in Selvi case Supreme Court for the first time issued various guidelines that narco analysis test and brain mapping test is violation of Article 20 Clause 3 of the Indian Constitution, because whatever information is obtained due to this kind of test is not voluntary statement, and whatever statement is recorded by investigating agency by putting accused in that category under this scientific method is not voluntary, and it is against Article 20 Clause 3. Investigating agency can use that statement for investigation purpose, but that statement cannot be used as a piece of evidence against the statement maker. So, this is another important case where National Human Rights Commission has played important role. Now, let us see how National Human Rights Commission and State Human Rights Commission can be made more effective. How to strengthen NHRC and SHRC. I have chosen this slide so that you can get entire information about National Human Rights Commission and State Human Rights Commission. So, let us understand this by empowering it to take action against police. Who are person? Police, many times police officers are involved, individual may also commit, who are involved in violation of human rights. So, my recommendation is that unless and until NHRC or State Human Rights Commission is empowered to take action against the police officer or individual, this agency would not be effective. So, that Act statute must be amended so that National Human Rights Commission or State Human Rights Commission can be given more power to take action against the police officer or individual who has violated human right. Second important suggestion which can be made to make this agency more effective, that is financial allocation. Budgetary allocation should be enhanced for organizing and sensitizing people for their human rights and police as well. So, budgetary allocation must be enhanced. Government should pass a budget, and in that budget there should be separate provision for awareness and human right education to the people as well as police, so that human right violation cases can be reduced or mitigated. The third important suggestion is special training programs should be conducted for CBI and police to sensitize them about human rights. Many times it is seen that police officers and CBI officers, they are not aware about the human rights or remedies available to the accused. Mere suspect or a person against whom FIR is lodged merely because of that ground, that person cannot be deprived from his precious right. Even that person against whom FIR is lodged has right to represent his case before the authority concerned in effective manner. So, it is necessary for the Parliament to make amendment in the Human Rights Act 1993, so that there should be a separate training program for police officers and CBI officer, investigating agencies, to sensitize them for making them aware about human rights. So, these are three important suggestions through which we can make these two bodies, Human Rights Commission, more effective. They can play important role in protection of human rights. This Human Rights Commission, you see, has drafted a model, has drafted a rule for investigating agency. That investigating agency, in the name of arrest, in the name of interrogation, cannot violate the rights of accused. In our legal system, accused can get all the rights, basic rights, human rights, which he can avail as a human being. So, he must be presumed innocent unless his guilt is proved before the court of law. Because of that presumption, accused in our criminal justice system is obliged to get all the benefits from the criminal justice system. So, this is all about your suggestions, valuable suggestions for making this body more effective, National Human Rights Commission and State Human Rights Commission. Apart from these suggestions, we can also get information from the website of Human Rights Commission, where Human Rights Commission has issued various guidelines for the prevention of police atrocities, for the prevention of custodial death, and National Human Rights Commission has power to award compensation in case of police atrocities, in case of custodial violence. National Human Rights Commission, in addition to court, in addition to judiciary, can give recommendation to provide compensation to the victim of crime. In addition to this, National Human Rights Commission and State Human Rights Commission both have power to make recommendation against the police officers, against the arresting officers, to the department concerned, that department concerned should take action against them, so that they cannot violate the human right. So, in this way, these two bodies, Human Rights Commission, can play important role, but the most important thing is that unless National Human Rights Commission or State Human Rights Commission is provided punitive power, power to punish the wrongdoer, power to impose penalty, unless this power is conferred upon Human Rights Commission, National Human Rights Commission, be it National Human Rights Commission or State Human Rights Commission, it cannot perform, it would not be effective unless this power is conferred by the statute. So, now time has come that Parliament should make clear cut provision in the statute, so that National Human Rights Commission and State Human Rights Commission take action against the offender. So, this is all about the recommendation of National Human Rights Commission and State Human Rights Commission, and most important thing is that protection against custodial violence, protection against custodial torture, and PIL, public interest litigation, role of non-governmental organization. So, many times it has been seen that the National Human Rights Commission and State Human Rights Commission are more cautious about violation of human rights. The problem with these two agencies is that though this act talks about establishment of district human right court, district human right court should be assigned to decide cases pertaining to human right violation. But the irony of law is that this act was enacted in 1993, the Protection of Human Right Act 1993, and this statute specifically talks about district human right court, but we have not established district human right court yet till date. So, the concept behind establishment of district human right court was to empower the district court to decide the cases exclusively pertaining to human rights violation cases. That part is not functional, and we do not have district human rights court, and even we this statute, what I am trying to justify, I am trying to highlight the negative aspect of Human Right Act 1993. This act talks about district human right court, but we do not have district human right court. Unless human right crime is identified, that what is human right crime, unless this human rights crime is identified, human rights offence is classified, we would not be able to protect violation of human rights in effective manner. So, district human rights court should be established by the government, by the state government, so that they can try the cases pertaining to human right violation separately, and it would be very speedy justice which is the mandate of Article 21 of the Indian Constitution. So, by establishing human right courts, we can provide speedy justice to the victim of crime. On the other hand, we would be able to protect the human rights of the citizen of this country, and district human court can also punish the wrongdoer, can also punish the offender who has violated human rights of the citizen. So, I think I have covered each and every aspect of human right, and I have tried to highlight the case of Supreme Court and High Court, and with the help of judicial pronouncement, with the help of statutory provisions, I have tried to explain judicial aspect as well as statutory aspect. With this, I would like to conclude this lecture. Thank you all.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP, you have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now, before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters. and maybe 3 teaspoons of vegetables. So, the WHO went with the 5-a-day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5-a-day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5-a-day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data. So, I will be doing it according to age, by gender and by your weight. So, apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So, for that I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors, like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So, approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So, data was converted and provided to the users, that is us, from the UK Data Health Survey. So, the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So, it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits, and as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So, what we did is, for falsification test, we took ear complaints and infectious diseases. Now, ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So, it is basically said a man should consume more fruits to impact his health, whereas As far as vegetables are concerned, they impact a women's health more. But this has been only seen as far as cholesterol is concerned. The various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now, after this we went in for a policy implication, and in the policy implication we tried to find two policy implications, what matters and exactly how much portion matters. So, as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So, an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has a impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I am not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I am also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.